Starting up a business is hard, really, really hard. Your chances of failure are high. You're likely to lose both your sleep and your hair. But luckily for you, you're not alone. Welcome to ET Startup School, your step-by-step guide to starting, building and consolidating your startup business idea. Your teachers at the ET Startup School will be some of India's best-known entrepreneurs, VCs and domain experts. So grab a notebook, pay close attention. School is about to start. Today's class at ET Startup School is called What Kind of Company Should I Start? Your teacher is Ganesh Prasad. Ganesh is a partner in the corporate and commercial practice group at Khaitan Co, one of India's leading law firms. With over 20 years of experience, Ganesh specializes in domestic and foreign venture capital and private equity investments in a variety of sectors. You may not know Ganesh, but you definitely know the brands he helped bring to India. Brands like Uber, WeWork and Booking.com. Hi Ganesh, welcome to ET Startup School. First question for you. Many founders typically work on a business idea when they're still in a full-time job. What are the legal implications of this?
It all depends primarily on the contractual arrangement that they actually have with their respective employers. Sometimes they have fairly exhaustive employment manuals, which sort of bars them and from doing any of these things. Whether while they are in employment of this particular company, if there is no bar, if they have done it outside of their employment time, from the company's time, so technically uh, it should be okay. But the IP in which most people, because most people have an idea, and that's an expression of an idea which sort of translates into a startup. So if they are working on it from a back end after their you know uh, time at the company, I think it's sort of okay. However, you still leave a small room for your former employer to sort of come back against you and litigate in case he finds that little challenging. We have seen those cases too.
You've seen that as well.
Yeah.
Now, what are the chances that an employer, suppose I had a full-time job, I worked on a startup on the weekends, I came up with something, I quit my job, I founded my startup. Now my employer calls me and says, okay, no problem. I just want a stake in your company because you were working for me while you came up with this. Is there a risk of the employer asking for a stake?
See, anybody can come and this is free India. They can ask whatever they want. I mean, they can. I have seen some ridiculous claims being made by some employers. The burden of proof then would be really on the employee in question that he did not use the company's resources of his former employer. He did not use the time of the during which he was actually employed. Of course, moonlighting today is a larger issue, which I think everyone has been talking about. So it really boils down to the employment manual, in which if a particular company has robust employment manuals where they say that you will dedicate all of your time no matter what it is, because I think with COVID what has happened is the line between what is office and what is home has actually gotten blurred. So it's very easy for somebody to make such an argument. But having said that, can you prove it? That will be up to the both of them who are warring eventually. But I think people should not really worry about it. Uh, I have one thumb rule which I've always advised people on. Go ahead, do what you have to. And if there is a brilliant idea and you have sort of done something that can always, and that's going to actually create value and that's going to unlock value in the larger ecosystem. Don't worry about the nitty gritties and the smaller aspects. They will generally fall into place.
That's good advice. So would the takeaway from this answer be that all employees should study their employment contracts pretty carefully or sit with a lawyer and go through their employment contract once just to be on the safe side?
Yes. The way employment contracts specifically are being designed today, and also because of the hybrid model what we currently are looking at, post the great resignation, if I may add, with the scarcity of employees. across sectors. I think it is very important that people actually come up with really robust employment agreements, wherein the IP is protected, and anything which, if you're, it depends on which side of the table you are. If you're on the side of the employer, the former employer in question, then obviously you will want to make it that much watertight.
Okay, Ganesh, assume that I quit my job. I came up with an idea. It's a reasonably good idea. I've got a co founder. And now I'm going to figure out what kind of company structure should I incorporate. So, what kind of structure should a startup founder consider?
So if you're saying you got an idea and that is the expression of an idea, and it's a fantastic idea, nobody has ever thought about it, and this idea is going to revolutionize the industry, and this is the thing which I guess the whole world was waiting for.
Hopefully. Yeah.
I think you should just go for a company rather than any other form. Well, you have various other things like a sole proprietorship or an LLP, and I'm not going to get into some of the other companies by guarantees and all of those things. But largely, if you are a startup entrepreneur, I think you should just go for a private limited company. Why? Because you can raise capital, you can have angel investors, you can have people invest in you, and eventually that will scale up, and you have a ready system which can scale up. I think that is my advice. But if your idea is not so mature and you're still exploring, like the exploring waters basically, then I would say start slowly, be a sole proprietorship. That might be a better option for you than take the burden of compliance, because a company has a lot of compliance related filings.
In legal terms, Ganesh, what is a sole proprietorship and what kind of business should consider this? What kind of startup should consider this?
Sole proprietorship is when you basically have just I would say you're the whole and soul of that particular business, and everything is run because of you, with maybe very very limited workforce. Uh, you do not have a formal structure to that particular entity. It's like a mom and pop dukan, as what we call it. That's usually a sole proprietorship. Where will it be relevant if you are possibly, let's say, depends again on the vintage of that particular employee. So if somebody who has sort of spent a lot of time, now he's on his retirement, and but he doesn't want to retire actively, but he wants to do some consulting work. So a sole proprietorship is better for him.
Oh. Next question. What is an LLP? What's a limited liability partnership?
So a limited liability partnership was basically uh, enacted as a piece of legislation. It came into existence. There was earlier the Partnership Act, which defined the relationship between people. Partnership Act, actually, the way it sort of defines under the earlier Partnership Act was it governs the relationship between a group of people, and it had unlimited liability. And then comes in the limited liability partnership concept, where the liability of the partners are basically limited. Now, today, if you ask me, uh, there is no difference. It's actually very similar. I would rather say, to a private limited company and an LLP, but the compliance obligation is a lot more in a company. But in a limited liability partnership, you do not have that level of compliance obligation. Earlier, there were certain things about dividend distribution, and there were certain tax advantages, but I think that has all been plugged. And I think, given that, I would possibly say it is not so attractive to somebody who is not very defined in terms of what they want, or what they don't know. They don't know where their company is going to go. It's in high sea, and it will all depend on market forces. That is where you go for a company. But when you know where you're going, then you sort of form a partnership. But that partnership is going to have limited liability, where the liability of the partners will be limited to the extent of their capital investment. So that is where it is.
Is there anything else that founders need to know about liability, the word liability?
Earlier Partnership Act obviously had personal liability. Now, in the current limited liability partnership structures, it is limited to the extent of normally, and again, we lawyers love these the grayness of the whole thing. Normally, as unless courts actually sort of go behind your assets, saying that there is apparent fraud or there is something else which you are guilty of as a named partner there, your liability is limited to the extent of the capital that you have brought in. So that was the actual intent of the LLPs which came in.
And unlimited liability, just to clarify, means that my personal assets are liable as well in case
Yes,
of
they go behind your
personal
um,
assets and
personal assets, and they can possibly attach whatever they wanted to. That was what was the
earlier partnership.
concept
So,
partnership.
what kind of businesses are best suited for LLP structures?
Earlier, we would possibly, because of the tax advantage which was there, we would sort of advise on uh, the some of these structures, but now and also the ability to raise capital. See, if you are going to get a sophisticated investor, he would not want to sit in an LLP. He would want to come in a company. If you want to go about and scale up that particular entity, you have the scaling up can happen in terms of number of investors, number of rounds of investments in a company better rather than an LLP. Usually, the way we see it today, law firms are LLPs. We see consulting firms as LLPs, audit firms as LLPs, tax firms as LLPs. So somebody who's in the consulting role, where they know there is a defined structure, they know whom to admit, they know whom not to admit, and they sort of are contractually in control of their existence and their future. Largely are people who should possibly go for LLPs. But when you are in high sea, you don't know whether you're going to sink or you're going to like really go to the shore, or maybe um, it's something which would be the blockbuster idea of yours, which would go listed on Nasdaq and NYSE and all of that. The company structure is always the better one.
Now, tell us, what is a private limited company in legal terms? You've, of course, said that this is one of the best structures in case you want to raise money, you want to scale. For all of those reasons, private limited is a good option. In legal terms, what does a private limited company mean and what does a founder need to know?
In an LLP, you have a partner, you have a designated partner who's basically the guy on whom all liabilities vest, the day-to-day operations vest, and the rest of them are not so liable on for day-to-day operations. But in a private limited company, there is something known as a perpetual succession. It doesn't matter if one of the shareholder dies, there is always it moves on. It's very similar to an LLP largely. I would possibly say there is this other element of directors who come in here from partners. There is a change directors. Now, director liability, unfortunately, is fairly large, and in private companies, see, you're going on chartering in high sea. Now, if you're going to charter in high sea, you will also have rough weather, which means the compliance part, as I would possibly put in, is a little more. And there is the concept of a common seal, which I think is a little dated today. But for certain documents, you don't really require a common seal. And there is a lot of compliance when you have to do rounds of capital raise, whether
What
it's a
does that mean,
rights issue.
Ganesh? A common seal? I'm sorry to interrupt you. Is that a legal term, common seal?
Yes, so I'll tell you, it's a colonial piece of hangover, uh, as I would love to call it, where you basically have a seal, like mohr,
Mm-hmm.
which is
So it's an
adopted
actual
by
physical seal.
it's
Yeah.
an actual physical thing,
Okay.
which actually embosses the paper on which it is, and that becomes the seal adopted by the company. So there are certain documents on which it could be a financing document. Some of them can actually insist. There are a couple of them where the common seal is required to be affixed. Then there is a perpetual continuity. The directors are there. then the shareholder, and then of course the liability is limited to the extent of the shareholding of each shareholder. Normally, again, I mean, again, it comes into the grayness part of it. There is a concept of lifting of the corporate veil, which is usually done in case of apparent fraud, where because liability is not associated with the shareholders normally. So I'll just take a step back here. You need to understand the difference between what is control and what is management. Now, in a private company, usually the management is expected to be run by directors. They can be directors, they can be shareholders, they can actually hold shares, or they may not hold shares. It can be a professionally run company. Now, if for some reason, uh, let's say I put two, three of my, uh, I would say, lack of a better word, somebody gullible as directors, and basically make them do all the nonsense that I want them to, controlling them from behind, then technically that means that I am the largest shareholder who actually is acting uh, through these directors. There are times when, if at all there is apparent fraud and such like, where the courts have actually sort of lifted the concept of a corporate veil, because normally liability sticks only with the directors, but sometimes because of mischief played, the courts have actually said, listen, it is not just the director there, it was you as a shareholder who was playing them, so I'm coming back to you.
And there have been instances where a founder has been removed from his or her post, right? If I'm not mistaken, the
Oh yes,
company. Yeah. So,
many times.
under what circumstance can a founder be removed from his or her own company?
It's a very good question. We always sort of see there is a contractual part of the story. Then there is actually the number of shareholding, what actually constitutes your actual shareholding in a particular company. Now, uh, if I'm going to continue, if I keep on raising funds and angel investors, then there is VC investment, there is private equity investment. So my 100% of my shareholdings keeps like dropping to a smaller percentage. Now comes a point when the investor basically has a right, because they come and it's like they will ask for the closest pound of flesh closest to the heart of the of the promoter, where sometimes they lose their companies.
Hmm.
When can that happen? That can happen when they fall below a particular threshold, or when they have certain rights which are contractually agreed upon, because when they invested in, they agreed to the promoter in question agreed to those rights. So then technically you can remove them from the company, but you cannot, let me tell you, you can remove, usually it is a case of you removing them from management as a director. You cannot take, and if you were to sort of go to the next level where you are effectively squeezing them out, or you're basically taking his shares, what we call as, you call upon his shares because they have defaulted on certain things, which are again provisions what you sort of see normally in typical VC investments. You're basically like, you've signed up your house, and you signed off your house to a bank, and you've defaulted there. What happens? The bank is basically calling
Can
you.
can claw your house away from
Yeah,
you.
absolutely. So that's exactly what happens. Normally, we see that it's a fairly contentious scene at that point in time. We have seen that in a lot of companies right now. That's where I guess some of the structures like preferential shares, which basically convert into a particular. This was actually a concept of which was a Western concept where it was from the U.S. jurisprudence. We had certain shares which would possibly vest in case there is a takeover, or for that, if somebody is trying to sort of reduce your percentage, then you exercise that particular right, saying that, listen, I'm going to now come back from, let's say, 10 to 51, or whatever that percentage might be. So there were certain of these rights which were included in Western jurisprudence. Now today, of course, if you are holding certain preference shares, or let's say if you are holding debentures which are convertible into equity shares of a disproportionate nature, then I think the promoter is actually in good shape. But it depends on what you agree eventually.
Ganesh, it seems like all startup founders should engage a law firm, but I'm fairly certain many of them are cash strapped and cannot engage a fancy firm like Khaitan and Company. So, what should a young startup firm do in terms of engaging a lawyer or a law firm?
Good question. Again, I would say, see, if you meet a lawyer, you see, usually when you go to a law firm, there are 90% of the people who come to us or to a tier one law firm come recommended through someone or the other who's a friend of a friend. You know them. You'll have some kind of a touch point there. And if that particular touch point is a genuine touch point, which is reliable and which is the source of reference, basically somebody who is reliable, then normally we have seen two things. One, you give certain shares to the lawyers uh, in the startup, and the lawyers basically spend their time and energy uh, in consideration for that particular consideration stake in that in such company. So that actually is not, you're not really going out of pocket in that sense, but you don't have cash, you're not paying them in cash, but it is non-cash consideration what you actually sort of end up paying. I would, whilst there are certain law firms which are actually doing that, but not possibly adopted by many of the law firms. Uh, some law firms, it's a handshake. It because we are in the business of relationships. We are here for the long run. And so what happens? It's a golden handshake in a different form and meaning, where you basically say, "Listen, I have come to you. This is what I can afford at this point in time. But the moment I raise my first round of investment, that is when you charge me." So it's a waterfall mechanism.
So
There
wait
could
till
be
I
that
become rich and famous, then I'll pay you your proper fee.
proper fee.
For
Until
now,
then, just take a token.
take it.
Just to give you some context, I have been paid by somebody who could not afford me. I don't want to name them. It's a very large company today
Mm-hmm.
uh, in Tirupati Laddus. Because
Tirupati laddus. I was
yes,
going to ask you if it is bottles of vodka or something, but yeah, Tirupati laddus is a good option.
he basically went to Tirupati and he said, "I prayed to the Lord to bless me and to make my venture a great success. And all I can afford right now is this amount of money and this as prasad."
This volume
I
of
said,
laddus, yeah.
yes. I just took the prasad. I said, "Keep the money. You will need it. We will see when you sort of become big."
Did they eventually end up paying you?
Yes, they came back as a good client, a very paying client. See, that's where I guess it's a call of the lawyer's faith in that particular idea. Because when we see ideas, we see a lot of ideas. We know what will work usually, because at the end of the day, our roles as lawyers, it has changed, it has evolved. We now are more like bankers. We know what will work largely and what will not work largely. So sometimes, if we see the novelty in that particular idea, we usually sort of like would like to participate. We also as lawyers, we're not looking just as um, at legalese or putting some document there. We also want to be part of creation of a
Enterprise. Okay, so that's good to know
enterprise.
that a founder can actually pay you with stake and hopefully not with laddus all the time, but they can hire a firm like Khaitan and Company if they negotiate the right amount of stake.
We do not take stake. Just let you know, at this point in time, we sort of like just defer it. We just say
Golden handshake and you come back when you're ready. But there are
yes.
other firms you're saying
There
with
are,
whom
there are, there are,
you
there are.
can negotiate a stake exchange for legal
Yes,
services.
yes, yes.
Ganesh, in 2017, a founder named Yogendra Vasupal, he went to jail for alleged fraud for apparently not paying back a vendor of his or something. What are the legal risks that a startup founder needs to be aware of? And if I'm a founder, under what conditions can I actually go to jail?
See, fraud is fraud.
Okay.
Whether you're a founder of a startup or whether you're a founder of you're a sole proprietor, or if I'm just sitting at my home and I basically don't pay somebody, it's basically fraudulent.
But jail seems a bit extreme.
Unfortunately, fraud is under Section 420, which basically is cheating, and that is the law of the land. Now, what happens? It's see. Usually, what happens here is uh, whenever we see disputes, and one of the key advice I keep telling people: please don't come to lawyers. Waste of your time, waste of money, and
You tell
just
them not to come to lawyers in spite of needing a lawyer
Absolutely.
yourself.
Absolutely. Don't, if you're fighting, the first thing which I tell people, please do not fight, just settle it out. Whatever the hell it is, just, do a handshake and just move on.
Mhm,
Cut your losses and move on. Don't spend money unnecessarily on the proceedings of courts. Don't
mhm,
spend money on, it's wasteful money. See, when you engage us as on a fundraise, when you engage us when you're going public, when you're doing an M&A, it's meaningful.
mhm,
It's a positive influence on the company and positive influence for everybody.
mhm.
But when you're actually going about and fighting because I either have an ego issue, or I refuse to sort of honor my commitments, or I have an integrity issue, then sort it amongst yourself. Do not come to us, because it's a waste of your time, and we will basically bill you. The courts will basically, they're already saddled with time. It's the typical what there was this movie. Tariq pe Tariq, and
Yeah,
you
yeah, Damini, yeah.
Damini. So it's one of those things which will end up, you'll basically go up the ladder, but you'll never know where you're going to go.
All right. So interesting advice from a lawyer. Try and settle with a handshake. Be amicable. If you can avoid going
Always.
to lawyer for disputes and going to the courts for disputes, avoid it.
Yes, yes.
Okay, your
Unless,
point.
of course, unless you strongly believe in it, that you have been wronged, and sometimes the value is high, very very high in
Is there
that time.
anything else about the law that a startup founder needs to know? Is there a law primer that every startup founder should go through? A basic law primer?
Integrity, honesty are two things which you need to start with, and it has to come from within. It is not something that you say that, listen, I am a very responsible business. No, it has to come from within, and that has to be the mantra on which you operate. If you are able to sort of comply with the letter of the law, if you are able to comply with what are the laws that really sort of affect somebody as an entrepreneur, or
Yeah,
like
how
for
would I
somebody
find
who,
that out? Because sometimes the law is written in legalese language. So, as an
yeah.
entrepreneur, how do I figure out what are the laws that apply to me?
So fair enough. I would possibly say, do you know something, that there is not a single company which is existing today, and I'm telling you this with hand on my heart. I have possibly about 20, more than 2 decades of experience, and all the poster boys of your of startups and everybody else, or for that matter, who have become mature, gone public, whatever the hell it is, there will be something or the other which is missing. Startups, the one advice I give is focus on your business. Don't worry about the law. Law will get fixed. Law is to enable business. It is not the other way around. Number one. Number two, what are the laws that you really need to sort of focus on? You need to know your employment law, which is your labor laws, because I think there are liabilities around it. Now, of course, if depending on the nature of the startup, how many people are there, what is the strength of the startup, and all of that. If they become sophisticated, not sophisticated, below 20, less than 10, all of these kind of things are there. It is something which you will need to sort of maintain records. It's main compliance. You will need to hire somebody who is possibly a lawyer or a consultant, or sometimes the chartered accountant also sort of doubles up there, and they sort of do this for you. The second most important thing which I see in the current context is the indirect tax regulations of this country. In the name of GST, I think there is so much of harassment, just general harassment by the regulators. So make sure that your direct tax and indirect tax books are in order, and your house is in order. If you have these three things in order, then I think you're good to go. Don't worry about the rest. Of course, if it's an idea and you're protecting everything else, all of those things in terms of IP protection, how you're going to sort of, whether it belongs to you, the strong employment agreements, your employee handbooks and manuals and all of that. It comes in that whole category of what I call as labor law compliance.
All right. Ganesh, what do startup founders need to know about trademarks, copyright, and patents? I recently saw somebody posting online that their clothing design was copied by somebody else, a startup's clothing design. But there's also a law apparently that says items of utility like clothing and furniture cannot actually be copyrighted or patented. So, on one hand, you get upset that somebody is copying you or infringing on what you think is your creation. On the other hand, maybe you don't know the law well enough. So, what do we need to know as entrepreneurs about trademarks, copyright, and patents?
Okay, so trademark is the trademark of your business. You obviously
Quite often, we call it a logo as well, if I'm not
logo as well.
mistaken.
Yes, of course. You need to sort of get it. If it's an idea worth in any salt, then obviously you need to get that right. You need to find your trademark. And unfortunately, the way intellectual property rights are, it's it's you have the European office, you have the US office, you have the Indian office, you have the Indian patent office, you have the US patent office, you have the European patent office. You will have to get a patent in each of these places. Yes. Now, in terms of the see what happens in terms of copyright itself. Let's say it's effectively the expression of all of those codes that you possibly have made your platform. It could be a design. Let's say to answer your question, what is that you are effectively looking at? I can't patent my design for let's say a piece of clothing. You can technically, but if it's a it's effectively a design. So there is a copyright in that particular design in the way it is structured and everything else. So I would possibly broadly classify that as a piece of intellectual property. If it is so significant that it is actually creating value for you, you should definitely go and protect it. The flip side to that is the moment you sort of make any application to the patent office, whatever novelty you have in any idea, that is actually in public domain.
You
So,
have to disclose it. Yeah.
you're disclosing it. What that means is there is reverse engineering which immediately kicks in.
Mhm.
Somebody will come there. There's a Chinese company which nothing against them, but there's a Chinese innovator. Let me put it that way, who will possibly come there and say, "Hey, listen, if I do the same thing differently like this, this can be achieved, and that is, and I can apply for a different patent."
Mhm.
So you just change a couple of the parameters and you get the same product. Those things are the risks that you run. Otherwise, you sort of keep it as a trade secret, in which case, I don't know how long you'll want to protect it.
Okay, India, of course, is the startup capital of the world with hundreds of startups and unicorns and all of that. The ecosystem is buzzing. But Ganesh, yet we hear of startup founders choosing to incorporate their companies in countries like Singapore or Dubai. Why are they doing this? What are the advantages and disadvantages?
Three, four questions. I very, very, very pertinent, valid question. One, I'll answer this in two, three portions. One, it's the ease of doing business. Second, tax rates. A Singapore company will have lesser tax rates. A UAE company will have lesser tax rates than the kind of taxation that an Indian company is required to sort of put in. If you were to attract financial investors, when they see a Singapore company, when they see somebody who is outside India, not that people don't invest into Indian companies. Like there is venture capitalists, there are private equity companies which are very very active. But there is this whole comfort level for a lot of the funds that listen, this is somebody who is a Western fund in their mind. It's even if it is in Singapore, it's in their mind a Western fund, no, a Western company. It's like it's well run. It's proper, possibly better than coming into India, where if I get into a dispute situation with the promoters, then I don't know what I'm trading on. It's thin ice. And again, we go back to the Tariq situation. Rather than sort of like just have certain agreements which are rather robust and which will be respected. Of course, Indian diaspora also, we have sort of crossed those bridges and we have our judiciary has been quite strong. It continues to be strong. we possibly are seeing dispute resolutions at a much faster pace than what used to be earlier, a rather long saga. But having said that, that's definitely an advantage. The third one, the sectors itself, the sector in which you're operating. Like, I advise a lot on gaming companies. I advise a lot on Bitcoin companies. Now the problem here is the Indian government's current view right now. They're going against all of the gaming companies. They're saying that, oh, listen, this is gambling. Now, even set principles are being questioned, and they get questioned every time. There is police action when you're sort of like, having a game like, let's say, a rummy, which is more or less a settled proposition that it is actually a game of skill. And there will be somebody who will basically go behind you and say, oh, listen, you're running a gambling den and this is prohibited, and I have the powers to sort of lock you up as a thing. Some of these things actually sort of matter. So depending on which sector you are in, and with all of these other parameters keeping in mind, people definitely are looking at other jurisdictions, and of course uh, the the lifestyle, which
Fair
possibly,
enough. That's a factor as well.
yeah.
Okay, Ganesh, final question. This question is about transitions. How easy is it to transition? Suppose I started a sole proprietorship. I want to become an LLP, or I want to become a private limited, or I incorporate a company in India and I say, okay, after a couple of years, I want to move it to Singapore. How easy or difficult are these transitions?
See, the more mature a company is, or more mature a sole proprietorship is, the more mature the entity is. It's like, see, you're basically the roots are spread. Now you're going to uproot it and you're going to put it into Singapore or what we call as an externalization structure. One, there are tax issues because there is, the first thing is that you're created value here, you're uprooting here, and there, it depends on how you're doing it, of course. Whenever you externalize anything, it is best done. Rather, I would not say that it's best done that you start in Singapore or in some other jurisdiction outside. But whenever you decide to sort of move, do that particular choice early in the ecosystem, because what's going to happen is, if you do not do so, I would say that the cost of compliance, and I would say the cost of, the severance of the umbilical cord between India and, eventually sticking it up, is going to be fairly a large number. That's something which is avoidable.
All right. Ganesh Prasad of Khaitan Company, thank you very much for talking to us at ET Startup School.
So thank you. Thank you for having me. Pleasure.
So that brings us to almost the end of today's class at ET Startup School. If you'd like to be a good student, check out and do the homework assignment in the show notes. If you liked the podcast, share it with family, friends, even your frenemies. ET Startup School is produced by Animesh Das with inputs from Anupriya Nair, Erika D'Souza, Arijit Burman, Shilpa Sharma, Harish Shavla, Govind Mundra, and Vishal Bhandari. ET Startup School is available on economictimes.com and ET Play, as well as Amazon Music, Apple Podcasts, Spotify, JioSaavn, and Google Podcasts.